If you are a Canadian employer who has been bringing foreign workers to Canada on work permits, the chances of you being audited by the immigration authorities increases with every new work permit that is issued to an employee of yours. And so it's going to be very important for you to be prepared for an immigration audit. In this video, we talk about how we've been able to help one Canadian employer navigate an immigration audit. Welcome back. My name is Donovan Francis. I'm a Canadian immigration lawyer at Goose Law Immigration, where we help businesses bring foreign employees to Canada without all of the legal hassle. In this video, we want to share a case study of a Canadian employer who we've been able to help successfully navigate an immigration audit. In this particular case, we had worked with the employer before to bring an employee to Canada on a work permit. When the work permit that the employee came to Canada on was one that was what's called an LMIA-exempt work permit, meaning the employer did not need to apply for a labor market impact assessment, an LMIA, but rather the employer had to submit what's known as an offer of employment through an online portal that the government has that's called the employer portal. And as part of that application, the employer needed to indicate the conditions under which the employee was going to be hired. So the employer would have indicated the salary that was going to be paid to the employee. The employer would have indicated the company benefits that would have been paid to the employee. They would have indicated the duties that the employee was going to be performing in Canada, and under what national occupational classification code the employee was going to be working. They would have indicated the physical location in Canada where the employee was going to be, among other factors. So all of this would have had to be included in the initial application. And so when that information was received by the immigration authorities, they subsequently reached out to the employer saying, okay, we want to know if you've been abiding by the terms that you indicated inside your offer of employment that you submitted to us through the employer portal. And so the inspection or the immigration audit had very specific requirements. They wanted evidence, documentary evidence from the employer for a specific period of time. So the audit would have been limited to a specific number of months. So let us say it was specific to 4 months, from October to November, December, January the following year. For that set period of time, the employer was mandated to provide to the immigration authorities payroll documents, to prove that the employee was being paid the amount that they indicated they wanted to pay, and not less or not substantially more. They wanted to see HR type documents to show what benefits the employee was receiving. They wanted confirmation that the employee was performing the actual duties that the employer said they were going to be performing in Canada, and that in fact the employer was not just merely using it as an opportunity to bring in somebody at a higher level under the guise of applying for somebody else. So they wanted supporting documentation on all of this from the employer, and the employer was given a set number of days within which to provide this information. And so the employer would have reached out to us asking us to provide support with this. And so just providing the documents is the easy part. The more challenging part for the employer would have been to go through all of their information, their payroll information, the duties, and everything else, and establish that they had been in fact conforming to the conditions. And more often than not, it will turn out that there may have been something that the employer had neglected to conform to. Some requirement might not have been met. And in that case, it is going to require a legal response. In one particular case, the salary that the employee was being paid varied from the actual salary amount that was written into the offer of employment. And so we had to make the argument that the variance was not substantial enough. You know, it was not significant enough to warrant the employer being penalized as a result of that. And so the employer was able to successfully navigate that audit without ending up being penalized by the immigration authorities. And so that is just an indication of some of the things that you would have to go through if your company were in fact selected randomly or otherwise to be audited by the immigration authorities. I trust you found value from this case study. As always, remember to like our videos so others will see more videos like this. Subscribe to our channel so that you will be notified next time we publish a video, and check us out on go.gooselaw.com. Thanks. See you again.